22 years on this bench. The ruling I am about to tell you about took me less than an hour to reach. It took the person on the other side 22 months to build the case she believed would prevent it. She lost. I want to tell you how, and I want to tell you why I have thought about this case more than most, not because of the argument, but because of the moment her 3-inch binder closed and her hands went flat on the table. That image is what this case left me with, not the ruling, that moment. She had paid her assessments for 4 years. Then someone taught her something, a theory, a framework, a community's certainty about a hidden truth in property law, and she stopped. She spent 22 months preparing the argument. She received 7 notices. She filed sovereignty documents instead of checks. And she walked into my courtroom believing that the right paperwork, the correct legal language, would dissolve an obligation she had decided she no longer recognized. My name is Catherine Merrill. I have been in this building for 22 years, 9 years defending people in that chair, 4 years prosecuting cases in front of it, 9 years deciding from the bench above it. The reason this case demanded narration is simple. What happened in that room is happening right now, in other rooms, to other people who were given the same tools and told they were keys. If someone in your life has been inside one of these communities of theory, if you have watched someone build certainty out of something that the record simply does not support, write that in the comments. I want to know what you saw. This channel is a record that needs readers, and every one of you who is here is part of that record. Subscribe and hit the bell. What I am about to describe now, stay with every word of it, because the number that started this was smaller than you are expecting. $1,432. That is the number she decided entitled her to declare herself sovereign. Not sovereign in the way people use that word loosely, the way someone says they answer to no one, as a kind of personal philosophy, a posture. Sovereign in the precise technical sense she had apparently spent considerable time researching. Sovereign citizen, in the legal theory sense, which is to say the sense that has no legal standing in any court in this state or any other, but which a certain population of people has come to believe is not only valid, but is in fact the hidden truth of American property law, that the courts and the banks and the homeowners associations are conspiring to conceal from ordinary people. $1,432 in unpaid assessments and accumulated fees. That was what she owed the Whitmore Hills Homeowners Association when she filed her response to their collection notice. A response that did not include a check or a payment plan or a request for an extension, but instead a 12-page document she had titled, in a font she had apparently chosen for emphasis, Notice of Sovereign Status and Non-Consent to Private Corporate Jurisdiction. I want to tell you about the morning that document arrived on my docket, because what happened in that courtroom over the 2 hours that followed is something I have thought about more than once since. Not because it was unusual, in the way that the spectacular cases are unusual, but because of what it revealed about a particular kind of certainty, and about what certainty costs when it is built on a foundation that the record simply does not support. I have been in this courthouse for 22 years. I have sat in 3 different chairs in this building, and I want to tell you something about what I saw when she walked through that door, before a single word had been spoken, before I had called the session to order, because what I saw in the first 30 seconds told me nearly everything I needed to know about how the next 2 hours were going to go. She came in ahead of her own folder. That is the thing I noticed first. Not ahead of an attorney, she did not have one, which I will come to, but ahead of her materials, which she was carrying in a 3-ring binder that was, and I am not approximating here, approximately 3 inches thick, tabbed, color-coded. There were, from what I could observe from the bench, at least 4 distinct sections separated by labeled dividers. She set it on the table in front of her with the deliberate weight of someone placing a weapon. She did not look at the HOA's representative who was seated across the table with a manila envelope that contained, as I would learn in approximately 8 minutes, 2 documents, just 2. She did not look at the clerk. She looked at me, directly, immediately, with an expression I can only describe as the specific confidence of someone who has done the research and is now waiting for the rest of the room to catch up. I have seen that expression before, not on her, but I have seen it. It is the expression of someone who has discovered what they believe is a hidden mechanism in the system, a lever, a code, a correct sequence of words that will cause the machinery to stop, reverse, and acknowledge that this particular person was always exempt from its operation. I have watched that expression arrive in my courtroom on people who have spent months building the argument they are certain will change everything. What I have also watched every single time is what happens to that expression when it meets the record. The record does not negotiate with theory. It reads the deed. The HOA's attorney, and I use that word loosely, he was a paralegal who had handled no fewer than 40 proceedings like this one in the past 2 years, and he knew this room better than most licensed attorneys I see, placed his manila envelope on the table with no ceremony whatsoever. 2 documents. He did not open them. He did not explain them. He simply placed them there, folded his hands, and waited. That contrast, 3 inches of color-coded argument against 2 documents in a manila envelope, was the entire case before anyone had spoken a word. I knew it. He knew it. The only person in that room who did not yet know it was the woman with the binder. What I did not know, and what I learned before the session formally began, was how she had arrived at this position. I want to tell you because it matters. She had owned the property for 6 years. For the first 4, she had paid her assessments without incident, $112 per month, which is not an insignificant sum, but which is what she had agreed to when she signed the purchase agreement and received the CC and Rs at closing. For 4 years she paid. Then, approximately 22 months before she appeared in my courtroom, she had stopped. She had not stopped because she could not afford it. I want to be precise about that, because it changes the shape of the story. She had stopped because she had, in those 22 months, been introduced to a body of material, through online videos, through a forum, through a document someone had shared with her that purported to explain the hidden structure of American property law, that had convinced her the assessments were not legally enforceable, that the HOA was a private corporation with no lawful claim on a sovereign individual, that the correct response was not payment, but documentation, the correct documentation, filed in the correct sequence with the correct language. She had been doing research for 22 months. I want you to hold that. Not idly, with genuine effort, with color-coded tabs. And in that 22 months, she had received 7 written notices from the HOA. 7. I want to name that number with the weight it deserves, because it is not a bureaucratic detail. It is the shape of what was given to her before anyone went to court. 7 opportunities to call the HOA. 7 opportunities to dispute the methodology if she had a legitimate dispute. 7 opportunities to say, I have a question about this assessment. I need more time. I would like to understand the legal basis for this charge. She received all 7 notices. She responded to none of them with anything resembling a conventional communication. To 3 of them, she sent versions of the same sovereignty document. The language got more elaborate with each iteration. This is what I had in front of me before the session was called to order. And I want to tell you what I thought sitting there with that knowledge, because I think it is the most honest thing I can offer about this case. I did not think she was stupid. I want to be clear about that, because the easy read of a case like this is contempt for the person who walked into it. What I thought was something more complicated than contempt, and something that I have carried in more cases than this one. I thought, someone told her this would work. Someone she trusted, or some community she had found, had told her that this body of argument was the truth the courts were hiding from her, and she had believed them, and she had spent 22 months building the case for her own exemption with genuine effort and genuine conviction. What was about to happen in the next 2 hours was not the product of her foolishness. It was the product of someone else's, visited on her at the cost of $1,432, and, by the time we were done, considerably more. That is what I understood before I called the room to order. That is the weight I carried into the first question. I gave her the floor first. This is not always my practice, but in a case where the defendant has chosen self-representation and has arrived with substantial prepared materials, I have found that allowing the full argument to be stated, completely without interruption, is the most useful thing I can do for the record. Not because I expect to be persuaded, because the record needs to contain what was actually argued, and because the person arguing it needs to understand that they were heard before they were answered. She spoke for approximately 14 minutes. I want to give you the shape of what she said, because it matters for what came next. She opened with a declaration, her own, not filed with the state, not recognized by any court, but a document she had created and notarized, and which she now presented as the foundation of her position, asserting that she was a sovereign individual, not subject to the jurisdiction of private corporate entities. She then cited a series of provisions from the Uniform Commercial Code that she had interpreted, or had been taught to interpret, as applying to property covenant law. They do not. The UCC governs commercial transactions. It has no application to recorded property covenants. But she did not know that, and I let her finish. She cited what she called allodial title, the concept that land can be owned absolutely, free of any superior claim. I want to tell you about allodial title because it comes up in these cases, and because understanding what it actually is tells you something important about the gap between what she had been taught and what the law actually contains. Allodial title in the modern American legal sense is functionally non-existent. The land that exists in this state, in nearly every state, is held in fee simple, which means subject to government taxation, subject to recorded encumbrances, subject to the agreements you entered at the time of purchase. There is no mechanism in Michigan property law by which a recorded covenant can be dissolved by the individual landowner's declaration of sovereign status. The covenant runs with the land. It was there before she arrived. It will be there after she leaves. She did not know any of this, or, and I want to be careful here because I cannot read a mind, she had been told a version of it that had reframed all of this as the hidden apparatus of oppression, which the Sovereign Declaration was designed to pierce. I listened to 14 minutes of this. I took notes, and when she finished and looked at me with the expression of someone who has just presented the winning argument and is waiting for the room to acknowledge it, I asked her one question. I asked, "At the closing on your property 6 years ago, did you receive a copy of the CC and Rs?" She said, "I did not consent to them." I said, "That is not what I asked. Did you receive them?" She paused, the careful kind of pause, the kind I have watched people take when they are deciding how much of the truth to give, when they understand that the full truth is going to cost them something they are not ready to pay. Then she said, "I may have received a document. I did not sign it." I said, "Your signature is not required for a covenant that runs with the land. The covenant was recorded before you purchased the property. Receipt is not the same as consent in the context of recorded property instruments. Did you read them before closing?" She said, "I do not believe they are legally binding on a sovereign individual." And there it was. Not an answer to my question, a return to the framework, because the framework was the only ground she had to stand on, and she had invested 22 months in it, and she was not going to step off it for a question from a bench that she did not, in that moment, recognize as having jurisdiction over her. I want to tell you what I understood in that exchange, because it is the most important thing this case produced for me, and I have gone back to it. She was not lying. She was not performing. She was defending a position she had built with genuine effort, and the position was wrong, and what made it wrong was not a matter of opinion or interpretation or the gap between two reasonable readings of a statute. What made it wrong was the deed. 4 pages, recorded, present. When I produce a ruling in a case like this, I do this. I read the relevant provisions aloud, all of them, every section of the CC and Rs that the HOA cited in its collection action, every clause that established the assessment obligation, every provision that described the enforcement mechanism. I read them into the record one at a time, in order, with the deed recording date stated before each one, so that the transcript contains not just my ruling, but the material basis for it. I did this because I wanted her to hear it, not as punishment. That is not what a ruling is for. But because there is a thing that happens sometimes when the actual language of the actual document is read aloud in a room where someone has spent months arguing against a version of it they were taught rather than read. Sometimes the room gets very still. Sometimes a person's face changes in a way that is not defeat, but something more like recognition. The moment when the thing you were told the document says and the thing the document actually says collide in the air in front of you. I watched her face while I read. I want to be honest. I do not know what she understood in those moments. What I can tell you is that the 3-inch binder, for the first time since she had walked into that room, was not open. It was closed. Her hands were flat on the table in front of her, on either side of it, and she was looking at the document I held, not at the tabs she had prepared. That is the image I carry from this case. Not the argument, not the moment I ruled, the closed binder, and her hands flat on the table, and the 4 pages I held that were the only thing that had ever needed to be in that room. The HOA's assessments were enforceable. The covenant ran with the land. The sovereign citizen framework had no application in this proceeding or in any proceeding in this jurisdiction. The foreclosure action was upheld. She had arrived owing $1,432. By the time the ruling was complete, with attorney fees and court costs and the accrued penalties from 22 months of non-payment, she owed considerably more than that. She owed it on a property she had purchased 6 years ago and had intended to keep. She owed it because someone, or some community, some collection of videos and forums and shared documents, had told her that the correct response to a legal obligation she disliked was to research her way out of it, not to negotiate, not to dispute, not to seek legitimate counsel and understand her actual options, to research sovereignty. She brought 3 inches of paperwork to a room that only needed 4 pages. The 4 pages were the ones she signed. I do not say that with contempt. I want to be precise about the difference between contempt and grief, because I think this case deserves that precision. Contempt would be easy. What I actually felt, sitting on that bench and watching the binder close, was something quieter and harder than contempt. It was the specific grief of watching someone who had spent genuine effort building the wrong thing, who had been given, by whatever source she found, a set of tools that felt like knowledge and were not, who had walked into that room believing the prepared argument was the sword and was watching it become the wound. I think about the other homeowners in Whitmore Hills. I think about them in a specific way, because this is where the grief becomes visible if you are willing to look at it. While this case wound through the system, 22 months of notices, then the collection action, then this proceeding, the shared expenses of that community continued. The maintenance of the common areas, the exterior repairs, the liability insurance on the shared structures. Every one of those costs was covered by the homeowners who paid their assessments. While one homeowner declared herself exempt, the others carried her portion. I do not know those people. I did not meet them, but they were present in that room in the way that absent people sometimes are, in the account of what was owed and what had not been paid and what the delay had cost. The neighbor who wanted to sell and could not because the lien on the adjacent property complicated the transaction. The fence that needed repair and waited while the legal process ran its course. These are the quiet plaintiffs in a case like this, the ones the sovereign theory never accounts for, because the sovereign theory is only ever about one person's exemption, never about what that exemption costs the people standing next to her. This is what the record produced when I closed the proceedings. Not a dramatic reckoning, not a public confrontation. A ruling, stated on the record in plain language, concerning 4 pages of covenant that had been binding since the day they were recorded. What it cost her, I named. What it cost the community, I named. What the sovereign framework produced for everyone involved, including the person who had believed in it most sincerely, I named that too. Because the record is not only the ruling, the record is the honest accounting of what happened in that room and why. I have thought about what I would say to someone who is watching one of these communities of theory build a case that feels like liberation and is building toward a room like the one I just described. I do not have a simple answer. I know what the law says. I know what the deed says. I know that both of those things are true before anyone in that community sends the first video, and they remain true after the last document is filed. What I can tell you is this. The difficulty of a case does not disappear when the ruling closes it. It travels. It goes home with the person who lost, and it goes home with the people who were waiting while the dispute ran, and it stays with me in the specific form of what could have been prevented and was not. One phone call, one conversation with an attorney who knew property law, one question asked before the 22nd month, before the binder had 3 inches of material, before the sovereign declaration had been filed and the court date had been set. That is what this case cost. And what it is producing, in the record, in the transcript, in whatever the next person reads when they are doing their research and they find this ruling, is a clear account of what this particular argument encounters when it meets a courtroom that is only going to read the deed. If something in what I described today felt like something you needed to hear someone say plainly, I am glad you were here for it. If you have watched someone you know go down a road like the one this woman walked, or if you have felt the pull of a theory that promised to exempt you from something that genuinely felt unfair, I want to hear what that looked like for you. Write it in the comments. Tell me the moment. Tell me where you were in the story when you understood what it was actually going to cost. I read every one, and I take them seriously, and I am not going to give you a simple answer, but I will give you an honest one. If what I do on this channel matters to you, 9 years in the defense chair, 4 years across the table, 9 years on the bench, narrating what I have seen from all 3, subscribe, hit the bell. What I bring here is the same thing I brought to that bench for 22 years. The record as I witnessed it, as clearly as I can give it to you. The folder is still in evidence. The deed is on file. The ruling stands. That is the case.